I am a lawyer. I'm an intellectual property lawyer, actually a patent attorney. And what I've done today is taken my general intellectual property course that I give to my coworkers at work and made it very specific about game design. And hopefully you will find this more entertaining than most intellectual property presentations. But I basically condensed an entire year-long law school course into about an hour and focused it almost entirely on game design. So I'm a patent attorney. I'm also a TGC Hall of Famer. I've won a couple game design contests at the TGC. I review games, computer scientist, husband, father, maybe not any of that in that order. I did successfully kickstart a game about a couple years ago. It just went through a second printing. I'm talking about that, well, some point later today again. You guys can be around for that. Anyway, I've broken this down. The first part of this presentation, you got to have a crash course in intellectual property. And I'm going to go through them really quick, and probably you're going to have a lot of questions, and you can ask me. I may give you the answer, but that might be legal advice, and so don't. But I'm going to start with patents, because patents are the one thing that people tend to run into, crash into, not knowing anything else about IP. But patents are the short, fat man of intellectual property. They have a lot of power, but they don't live for very long. They're very expensive to get. A patent is essentially a promise by the United States government, or a right by the United States government, for you to prevent others from making, selling, using your patented invention. It's a long process to get a patent. It's not easy, it's not cheap. But at the end of the day, if you successfully get a patent, you get a little ribboned patent, and you get a set of claims. The entire power of a patent is that it protects very specific things that an inventor has claimed in their invention. So if you see a patent that says for a board game, and that's all the description says, you know that there's something more buried in it. What I did was I pulled the game board patent from a very early Monopoly patent. And you'll see I highlighted a handful of words here, so that what is really being claimed in this patent is just a board with a starting space, I can't even read my own screen, that's in a quarter, and a series of colors along each edge of the game board. If you create a game that doesn't have all of those little pieces in it, then you know what? You're not inside the patent. You can't be stopped from making it. You can go on and do other things. However, what it does do is prevent, it allowed the owner of the patent to stop people from making other games that had a start space in the corner. What this means for game designers is, by and large, these are ones that you're going to hear about. You'll see them in forums talked about. We'll talk about another one a little bit later. But in essence, these are typically very narrow restrictions, but very strong. They offer a lot of authority. They tend to lend credence to the person who holds a patent, that they have actually gone the next step above and beyond and described something that at the time of the patent was new, it was useful, and it wasn't obvious. So nobody had invented a game like Monopoly before. They had all of these little claim limitations in there. And what this really means for the board game world is that the handful of patents that are out there, if you look at them, you can usually work around them. And we'll talk about that a little bit towards the end. But a patent is short and fat. It lasts for about 20 years. It's limited to whatever is described in those claims. And it allows the owner of the patent to prevent other people from making copies of that exact claimed invention. So the other one that people will talk about a lot on the internet, especially in forums, is trademarks. You'll hear a trademark right is basically a word, phrase, symbol, design, anything that distinguishes one product from another. If you went out and made a board game called The Game, or a card game called The Game, for example, you'd have a really hard time stopping other people from making another game called The Game. By the way, that's a real game. If you've never played it, it's great, it's fantastic. But they're going to have a really hard time stopping other people from making another card game called The Game. On the other hand, if you have creative names, if you have pretty illustrations as logos, if you have something that's memorable, that's made up, that's imaginary. All of those words can create a trademark. They will separate your game from the rest of the industry. People generally know Yahtzee from its imitators. People know Catan from its imitators. Any one of these things would act as a way to differentiate a game name, a product name. There's no real limit on what you can trademark, except if it's really descriptive. For example, the game would not be a good trademark, but just about everything else that you can think of. It could be a color, it could be pictures, it could be words, it could be made up words. All of those things are protectable as a trademark. I can hear myself. That's all right. The one thing I will say, and the nice thing about a trademark is if there is another product on the market that carries a similar name, it does give you some right to prevent those people from trying to sell the similar sounding name. Now, one of the things that comes up in almost all of the discussions about trademarks, especially with board game designers who go, well, can I use the title of a movie, or can I use the name of another game in describing my game? Can I use something that people will recognize as, for example, the Super Bowl? I don't want to have to say the big game that's played in January between the two best football teams in the league. There is a concept of nominative fair use, which says that you can literally use the trademark in the way it was intended to describe the thing you're trying to get at. I don't need to say the dice rolling game where you're trying to get a bunch of similar numbers in a row. I can just say Yahtzee. It doesn't let me use their logos. It doesn't let me use anything else, but I can say my game is a lot like Yahtzee, or this is a Yahtzee-like game, or something like that. It's called nominative fair use, and this comes up for board game designers all of the time, when especially making pitches. Even if you're using it on a card, if you have the players in the game playing a meta game of Yahtzee, you can say something like that, as long as it's necessary to identify the product or service. So the seminal case on this one is one by the New Kids on the Block. They sued essentially a contest site that was using New Kids on the Block, and they won. So there is now a trademark case that features the New Kids on the Block as the one that everybody points to as why you can say the New Kids Not on the Block, not the boy band from, well, forever at this point, 90s. You can say the New Kids on the Block without worrying about a trademark lawsuit just because you want to reference New Kids on the Block. We'll talk about why I probably can't use their picture, but that's something later. So the other one, the other point at which board game design sort of intersects with intellectual property comes up in copyrights. And this will be the bulk of what people use, make, design, put together in terms of board game. And it's the probably most transparent, most non-obvious part of what's going on in the background. But what copyright is, it's a federal law. It is enshrined in the Constitution that basically protects original works of authorship fixed in a tangible medium of expression. That means if I have an idea and I want to write a murder mystery, the copyright does not protect the idea in my head about a murder mystery. It protects the actual expression of that murder mystery when I write it down, when I type it out. It's not the card drafting game that I have in my head. It is the actual expression of that card game that I have put out. So it could be my prototype version, it could be the published version, but that version that is fixed on a card, on a board, in a rule book, that version of the art, the rules text, the logos, the designs, the icons, the fonts, that is the meat of copyright protection. It's not the general idea. So one of the related concepts, and again, we'll talk about this when we get a little bit down into the weeds a little bit more, that comes up a lot and a lot of people talk about is fair use. Can I just use this because I'm not really making money on it, or Like clearly they meant this to be used. In general, using copyrighted works for, quote, fair use reasons has to meet a very narrow exception. And I'll tell you the legal problem with this is that if you're getting down to the fair use argument, you've basically already said you've copied somebody's work and you're using it you're using it. So you're basically in defense land. And I'm going to tell you, unless you intentionally go in thinking you're going to comment upon, criticize, or basically educate about a specific work, you're probably not in fair use land. Now, lawyer disclaimer, you might have good arguments why you're in those places. But in general, I'll tell you, most game designers are not going to be in parody. They're not going to be in satire unless they're specifically doing that intentionally and on purpose. But I won't get into the long explanation of what parody and satire are, because that's a 3-month course in law school. There are a couple other sort of quasi-legal areas that I just want to talk about real quickly because they do come up. Plagiarism in particular comes up all of the time. I could complain about all of the 3 game designs that are out there that look an awful lot like my games. They don't use my art, they don't use my icons, they don't use my logos, they have the same general theme, they have the same general mechanics, but because it is what looks like a very similar game but done completely differently, that is much more in the realm of plagiarism. Plagiarism is not a legal right. You can't go sue somebody for plagiarism. It is a moral failing of the person who plagiarized you and didn't credit the source. It looks a lot like copyright, and sometimes when people talk about plagiarism, they talk about the idea that it looks too close to my own, that I feel like something's been taken. But in reality, that is just a conscious board game community. We don't like people who just take ideas and reskin them instead of an actual legal right. On the other hand, if you do have art, logos, rule text, other things, and we'll talk about an example, I hope it's at the very back of this, where that turns out to be the case, there is for real copyright claim. The other thing that comes up for board game designers is, well, what do I do about my idea in my head that I haven't written down on a piece of paper, that I haven't gone out and spent $20,000 on a patent attorney to file a patent application, wait 3 years to get an application granted into a patent? They'll sometimes come and say, well, can I just get a confidentiality agreement with all my playtesters and the publishers I want to pitch to so that they can't go and steal my idea? You can. It's probably not a really great idea. We'll talk a little bit why that's just a barrier for most people. But there are ways to protect truly legitimate trade secrets. But the trick here is you got to treat it like a secret, and you can't share it to the world. So it makes it really hard to do playtesting, to show up to Protospiel, to show off your game designs. It's more like the Coca-Colas of the world, although that formula is kind of half known now. It's got to be actual secret, locked up in a vault. You only let limited number of people have access to it. You can certainly try getting a confidentiality agreement. I will tell you, I will not sign one here, just in case anybody's wondering. And then you still have the problem of proving that it was confidential, that nobody else knew about the idea, that you still got to go sue me in probably state court here. Good luck with that. That's all very expensive. And then you still have to prove that you were actually harmed by some idea that was taken, and that's a very uphill battle. So these are out there. I will tell you they're not very effective for the purposes for game designers. So intellectual property comes up in a bunch of ways in our game designs, and I am going to go through a couple of the places that you will hit upon intellectual property. The first is in mechanisms. So now if you'll remember, I know I've been talking really fast, but there are not a lot of ways to protect game mechanisms themselves. There is one place that does, but this quote here is right out of the laws, which says that copyright won't do it for you. So this is the one. It's pretty easy to get a copyright, but it will not protect your game mechanic idea. So if you created a brand new card drafting mechanism, it's not going to help. Copyright is not going to help you. The only the only thing that it helps you protect is the very expression of that mechanism. So for example, if I wrote down the rule that I'm going to make a deck unbuilder and I'm removing cards out, that general concept is not protectable by copyright. If I write the rules as I write them will be protected by copyright. The cards themselves will be protected by copyright. The mechanism itself will not. The only way to get a mechanism protection is by actually filing a patent application. This comes up all the time again in discussions about board games. This is the tapping mechanism in Magic the Gathering that was actually an issued patent from the early 90s. You'll note that this patent actually is expired, so go ahead and use the tapping from Magic. But in any case, you'll see that what they did was went ahead, and I don't think I highlighted this one, but they actually have on this, in their patent claims, a description of how you tap and exhaust in a Magic game. And so that was protectable by Wizards of the Coast for a long time, 20 years from the date the application was filed, so it expired a number of years back. There are a handful of examples of these sorts of patents and patent applications out there. They are few and far between. Tiny Epic, one of the Tiny Epic games with their little meeples that you stick swords and weapons on, they made some news a couple of years back because they sought a patent application on sticking little plastic pieces onto the meeples themselves. I have written about that patent application and why it probably makes sense for them, but it probably doesn't make much sense for most of the game design world, in part because it is expensive, it's hard, you still got to go enforce it against people, which is also expensive and hard, and by the time that your game comes out, your application, the thing that you file with the United States Patent Office, very likely will not have issued and matured into a patent. So if you're trying to stop copycatters, it may be too late to do that sort of protection unless you're way ahead of the curve and you file your application way before you start publishing and making it known to the world. On the other hand, if you sell millions and millions and millions of dollars worth of card games, it might make sense for you to go get one. As game designers, the other thing that sometimes comes up is people who want to make unofficial expansions to games, and in which case you run into a number of other places in which intellectual property shows up and makes it somewhat hard to make even unofficial expansions. You're going to run into the fact that the game, the characters, the world it's set in, potentially even place names and elements, icons that are on or in a game will all be protected in one way or another, either by copyright, potentially by trademark if you're using the game's name itself, or elements of the game. Again, you can refer to the game as an unofficial expansion for Catan that way as a nominative fair use, going back to the beginning. But you're going to have a hard time if you want to use the Catan logo, if you want to use any of the iconography, any of the words, any of the verbiage, any of the flavor text. Interestingly, and I think I might talk about this too, certain of the piece names, things like that, how they refer to elements of the game wouldn't be protectable, but you're going to have a hard time. You're going to run into, you're going to run directly into sort of overlaps between iconography and rules texts and things like that. It is possible to do it. There are ways, but you've got to keep all of those things in mind as you're going through your game. One of the really important things, though, is the themes of games themselves are not protectable by either patents, copyrights, or trademarks. So, for example, if you just wanted to pick a game on an island with people who need to harvest resources by die rolls and for some reason that's how they live, you can do that. There's nothing that stops you from basically taking the settlement mechanics of the settlement theme, the island theme from games and making it your own. It's the ambiance, it's the theme, it's the just general subject matter, murders, mysteries, even the fantasy realms, things like that. You can't, there's no protection for that in a general concept. The specifics, the actual expression of those worlds will show up as copyrights though. So the other one that comes up from time to time, and I mentioned it a little bit earlier, is what happens when you reskin a game. You run headlong into the plagiarism issue, but as long as you avoid using the original rules, as long as you avoid using any of the elements of a game, as long as you avoid using the trademarks, imagery, artwork, things like that, you can. So the game on the left here is a reskin of the game, which is literally a set of cards numbered 2 to 99. Guess what? There's no real protection on a deck of cards numbered 2 to 99. I didn't use any of the artwork. That's actually Beth Sobel's textile artwork. All I did was took her artwork, we put it on a set of cards. Guess what? Publisher still got mad. So we, so even with that in mind, there's a very negative reaction to even offering reskins of things because I just didn't like the skulls in the original version of the game. Now they now have a better version, but yeah, so you can do a lot of things. You can reskin. There's nothing that prevents you from doing that. It's got to be basically a whole new skin though. So this brings us to protospiel and prototyping, and what can you do to, with art, with copyrights, with trademarks, even in the context of prototyping. And I'll tell you that same rules almost all apply in this environment as they do even if you were out to go out and publish. There's one gigantic exception, and we'll go into that a little bit. But when you're prototyping, the moment you go to someplace like the Game Crafter, a lot of the protections that you might have of if you were just home printing it for your own personal use sort of go away. So we'll talk about that. But as long as we are there, there are a number of ways that you can still run into copyrights, trademarks, patents. But we'll start with the most obvious set of things, which is when you're building a game, even for a prototype. Your arts, your icons, your fonts, those are all going to be subject to some amount of copyright in general. And the best and safest route to avoid any sort of intellectual property copyright issues is to find art, icons, fonts that fit one of the 4 categories at the bottom. You're either commissioning it from Alicia back there, who needs more work, or you are licensing it from a stock art site, you're searching the public domain, I'll go into that in a little bit, or you do the hand-drawn art yourself, and that often has mixed results unless you're Alicia. So the first place to look, and I happen to find this to be one of the more effective ones, is you can always look to the public domain. So copyright runs, it protects the literal expression of the art, the work itself, the thing that's actually laid down, but it doesn't protect it in perpetuity. It does run out. The current cutoff is 1923, so art from before 1923 is in the public domain, so famous works of art, books, illustrations, things like that will all be within the public domain. And when something's in the public domain, you can use it without restriction. You can sell it, you can mutilate it, you can make it your own, you can claim it as your own. There's no restriction to that. Yeah?
Super quick question on that, though. I thought that the reproduction, so the photo could be copywritten separately, owned by the photographer or artist.
So in copyright law, at least in the United States, so big disclaimer, most of this I'm talking about is in the US, so if you're listening internationally, it may not apply. Slavish reproductions, including a photographer's attempt at recreating it, gets almost no literal copyright. So they can make that argument. Museums almost always do, that they make their money from selling CDs of famous works. But in reality, there's almost no protection to it. You got to find that nugget of creativity, and it's funny because the harder you work to make a slavish reproduction, the less creative that outcome is. if you were to take the same picture and put it inside a beautiful frame, inside a, a backdrop that adds some creativity, you're moving away from slavish reproduction and into creative space. But yeah, a photographer's recreation, a scan, near photographic reprint has almost no copyright protections. Notwithstanding, like I said, people's attempt to do that. There are a couple other exceptions. They're really hard. It's really hard to prove up. When I made the game Starving Artist, I used almost exclusively public domain artworks, ones that were essentially painted before at the time, 1922. There are a handful of art pieces in the game that were post-date that, but they fell into the public domain for other reasons that I don't want to get into. If you have questions, you can ask me, and I will point you to a website that has an exhaustive list of the ways things fall into the public domain, mostly for failing to say copyright during relevant time windows, and it's really arcane. There are a couple other things that you should know. There are a whole bunch of things like facts, ideas that automatically drop into the public domain. So you cannot get a copyright over a fact. I wish I had a snappy fact to recite right now, but copyright, anything published before 1923 is in the public domain, is not a copyrightable element because it's in the public domain as a short fact. Clips and phrases equally are not copyrightable. There is some protection for things like catchphrases if those catchphrases are also a trademark, so they identify a source. But otherwise, you can take a sentence, you could take a short clip or phrase, and it's going to not be itself copyright. Works of the United States government is a fantastic source of modern photography, art, space, NASA. A whole bunch of US government works are all in the public domain automatically by law. I doubly footnoted this because there is some exceptions if you're a contractor for the United States government that some of those works may not fall automatically to the into public domain. You can always look, they're usually on the website, it tells you which ones are not subject to that rule. Copyright expiration, and there are occasionally, you'll find art or works that have been donated to the public domain. So an artist who affirmatively says, I am waiving all of my copyrights and I'm donating this to the public domain. Those happen occasionally. We'll talk about Creative Commons in a second. If you find stuff like that, you can fairly safely use that, at least in the United States. Public donations to the public domain are kind of tricky because it's unclear what happens if a author or artist decides that they want to take it back. What you will not see on here is Google Images, you'll not see Twitter, you will not see Board Game Geek. None of those things are sources of the public domain, even if they are used widely and spread across websites that monetize copyright infringement. Neither are memes, by the way. The other way to get legal authorized access to art, to works, to basically anything that falls within copyright, patent, trademark is to get a license. There are a whole bunch of ways to do this that don't involve negotiating with the actual authors themselves or the artists themselves. Stock sites all have license agreements on them, so if you download something from Shutterstock lawfully and not with the little watermark on it, you will have a license of a sort from there. Every artist that you commission should provide you with a license to use your art you just commissioned. And you can, if you want, attempt to go directly to the publisher. For example, if you wanted to do an unofficial expansion and ask for permission, even an email that says, sure, go ahead, you can do it for whatever purpose, would be sufficient as a license from the publisher. Now, they can still retract that, so you should be careful. But you can try that approach. It's worked for a couple people for unofficial expansions or for, I just want to do this for myself and not sell it to anybody. Is that all right? In essence, what a license says is, I'm not going to sue you. And so go ahead and do exactly what my license says, and you're fine. I'm not going to sue you for that. What most game designers run into really quickly once they start looking for art and designs and other works to include in their games is they're going to run into Creative Commons. That's one of the most common copyright license agreements out there, and there's a whole bunch of versions of them. If you are looking at anything, whether it's photography, illustrations, short clips and phrases that are text to include as in your books or your cards or your boards, you'll probably run into one or more of these. I have flagged the two that you can basically use without any real thought. You can use the Creative Commons by, which is just an attribution license. The question that comes up about attribution is how do you attribute, where do you attribute? Basically, the rule says anywhere that's reasonable. So if you wanted to include the attribution on the card or the board itself, if you wanted to include it at the back of the rule book, there's nothing that says or prescribes exactly how to attribute, but you can do that. So you can use it freely, you can use it commercially, you can sell it on Kickstarter, you can sell it on the Game Crafter as long as you're doing the attribution. If you don't do the attribution, you risk being sued for copyright infringement. The other one that is almost always safe to use is the Creative Commons 0, which is their donation license, which says that the author is basically waiving all copyrights to that. Again, it's really not exactly clear what happens if an author wanted to retract it. And usually that's a right of the authors, although once you make a donation to the public domain, who knows? But it's fairly safe, and even if they did retract it, I don't know what harm they would have for any sales that happened before that retraction and before they let you know. There is one that I will just call out to be cautious about, and that's the anyone that's marked no derivatives. The problem with derivatives is if you take it and you make it a little bit different, like for example, I don't know, you crop it, is that a derivative, and then you can't use it because it said no derivatives. So if they wanted the art expressed exactly as it was shown and you can't crop it, you can't change the colors, you can't change the focus, all of those things make it really difficult maybe to use as a game prototype. But if you can fit it exactly as it is, you don't blur it, you don't obscure it, you should be fine again as long as you attribute them. So I flag as don't use, don't even just bother going down this path, is anything that's listed as non-commercial. There's a couple reasons for that. Anything that's listed as non-commercial almost makes it impossible for you to print it professionally, even for your own purposes. So it may surprise you that sending your non-commercially, any artwork that's licensed non-commercial to the Game Crafter has a commercial component. I don't know if JT wants me to give this secret away, but they in fact make money off printing out that good, and that is a commercial endeavor. So even if you're using it only for yourself, you don't intend to put it up for sale on the Game Crafter, you don't intend to kickstart it, you don't intend to do anything other than show it at Protospiel, there is a commercial aspect to it, so it's just not worth the hassle. You may still get kicked by the reviewers at the Game Crafter. If you did just print it out at home for your own test purposes, you're bringing it to Protospiel to use as your test case, non-commercial is probably okay in that situation. If you're using it, even if you print it out and sleeve it yourself and send it off to a game reviewer or a previewer, guess what? Again, there's a commercial aspect of that. You're attempting to sell it. You're attempting to get media or press. The reviewer is using it for probably their own purposes. They may be taking pictures. Again, it's probably not the greatest scenario. So I recommend anything that has a non-commercial element to it, which is a vast majority of sites, you be very careful about how you use those licenses because it will dramatically limit your ability to use those prototypes. So the last part about this, and this comes up, and I really hope my last slide got in here, is now that I've gone through all of these things about intellectual property, it's been mostly talking about it from the other side of this fence, which is I want to use somebody else's art, or I want to use somebody else's patented idea or game mechanic. But what happens if you yourself have done something, you've created a prototype, you've got a great idea, you've even maybe commissioned Alicia to do artwork for you, you made your own. I'm giving you pitches, Alicia.
I can tell.
And you go to Protospiel, and all of a sudden you start to see that your game idea is popping up everywhere, and somebody's stealing your ideas, and oh man, they've even maybe stolen your name. Like, what can you actually do about that? So let's quickly go through this. Again, stealing an idea, frowned upon by the community, especially if it was new, novel at the time. Maybe it was like, holy cow, this is a great idea. You can get a little bit of protection from the community from a plagiarism perspective. There are vocal people who detest plagiarism. You might be able to get some protection from NDAs and confidentiality agreements if you got those in place, but that's, again, a big uphill battle. Copyrights aren't going to work for you. A patent's probably would definitely work for you. It's going to be way too late, though. Even if you filed your application, it's a very long, expensive process, and then you still got to hope that the person who stole your idea has money to take at the end of the day. Stealing your ideas, this is a very collaborative community. It's really hard to protect an idea in and of itself, whether that's the theme, whether that's the world that you're building, whether that's the game mechanics that you just invented. It's all a very difficult proposition, especially at an early phase. Your specific expression of it, however, oops, that's the, let's go to your name instead. So let's say you have this really great idea for a game called Starving Artists, and somebody else comes out with a game called Hungry Artists or Starving Artists, even an exact one. Really the only recourse I would have in those cases, again, other than the plagiarism community backlash, is a trademark. Trademarks are automatic. So the moment I start selling a game, the moment you start selling a game, and you've made your first sale, and cross your fingers, it's across state lines, you actually have an enforceable trademark right that you can start to use against the people who stole your game idea, or your game name idea. You do not need to register your trademark. I did use the registered trademark symbol because that's what people know. Registered trademarks just give you the same trademark rights across the country the moment you have your first across state lines sale, and lets you enforce regardless of where you made those sales. If you don't have a registered trademark, you're limited by geography. The interesting thing about the world today is the geography doesn't make a lot of sense anymore. This isn't, moving widgets from Wisconsin to Minnesota. People are selling over the internet. You're using Kickstarter. You're using the Game Crafter. You're going to have a lot of territorial expanse the moment you have your first sets of sales. I've said it a couple times for any of those picking up on it. You don't get trademarks in something you don't sell. So if your game name at Protospiel is something that you have not yet sold at the time and you aren't selling it, you don't have any very near-term plans to sell it, you're not going to have trademark rights. It comes later when you start actually making sales. You can file an intent to use application with the federal government that says, I'm planning on using that mark. That's kind of like a reservation, but it doesn't give you protections until you actually start to sell. Yep.
Selling in my home state via Game Crafter in another state to my home state, does that trigger that?
The Game Craft, you order your own game or your...
Somebody else, my neighbor.
That's a consult with a lawyer one. So I will say that it's tricky because on the one hand, there's a couple things going into my head that when you say that. One, is it across state lines? And two, you got to have slightly more than a single sale. It can't be just a nominal sale. You can't have just a token sale. You can't get around this rule by having your friend in Iowa buy from the Game Crafter in Wisconsin. Like those don't work. Courts see through that. It's weird. Lawyers tend to be smart. So those sorts of gimmicks don't work. But yeah, I mean, I would argue you would file an application and you would have the interstate commerce requirement if it was a legitimate sale from Wisconsin to, say, Iowa or Minnesota, something like that. Sale to yourself doesn't really count though. I will talk quickly about this because it is probably the most dramatic and most interesting aspect of what happens when somebody steals something. So copyrights are actually really strong. They are automatic. They apply the moment you put pen to paper, the moment that printer ink hits the paper. Your copyright attaches to your original expressions. So your game design, your art, your text, your potentially your graphic design, things like that, all of those things apply. Copyright is federal. There are a whole bunch of protections that apply that you can sue directly the infringers. There are also a whole bunch of ancillary reasons why copyrights are, somebody who tries to steal your art directly or your copyrights directly, there's a whole lot of other protections, including the Digital Millennia Copyright Act, which allows you to issue takedown notices. So for example, if somebody took your game off the Game Crafter, decided to go to Kickstarter, and they literally used your shop page photos, they use your games, they use your rules, Kickstarter has an obligation to not let a copyright infringer do that. Ditto if somebody stole your pictures off Twitter or Instagram and tried to reuse them for their own games. Those laws apply almost immediately, and you're able to sort of exercise those rights without getting a really expensive lawyer in the works. You can do that, so you can issue takedown notices. The other interesting thing is you can actually get US Customs and Border Enforcement protection too. So if you know that a huge batch of your copyrighted games is coming from China at a port of entry, and you know that this is coming soon, you can actually relatively easily get them to seize that shipment, and then you can decide what to do with it, usually burn it. And then you have the more expensive option, which is you can actually file a lawsuit for copyright infringement.
So if I went and had my prototype printed, it would be covered then, right? Is that what you're saying?
Yeah.
And if I changed it then and had it reprinted with modifications, that then would be
Yep.
covered as well?
So you've run into the gigantic problem of copyright. There is problem of copyright. There is this sort of perpetual, it's automatic. There's no more formalities rules under copyright law, so you don't need to go register. You don't need to put copyright Mike Wokasch at the bottom of the presentation if you tried to take this and use it as your own, because it's such an amazing presentation. I guess I could sue you for copyright infringement. It's automatic. Like the moment you printed it, the moment that you wrote it down, the moment that you started typing words into your Excel spreadsheet and did something with it, yes. So it basically attaches at that moment. There is a publication requirement, so the printing helps, but yes.
How would you ever prove that?
How would you ever prove?
Yeah, somebody could retroactively say, oh, I've written this down at least before you did. How would you ever prove that?
Yeah, so copyright also has a rule, I'll answer your question in a second. Copyright also has a rule that basically says people independently can also come up with the same ideas and almost the exact same expression. It comes up from time to time, more in music than anywhere else, where basically independent of each other, they had developed the same idea. In that case, both people would own the copyright and there would be no claim of infringement that you could prove. One of the things that you do in an infringement claim is you got to prove access. So like if some random person across the world came up with the same idea, they didn't know you, they've never met you, you can't prove you were in the same place, that they had access to your document, that you didn't, like they didn't see it on Twitter or whatever that you were talking about. You got to prove in an infringement claim that there was actually access. What's interesting is some of these other scenarios like takedown notices, that question of access becomes a lot harder and is definitely a source of contention among people who think that takedown notices, automatic takedown notices without sort of that level of proof and requirements is unfair to people who are using the copyrights. But yeah, so it will be your burden to prove that they had access to your work in a way that let them copy it. It's insufficient just to say, look, it's the exact same thing. Long way around to that answer. I don't actually have, I thought I did. This just came up, by the way. There was a great article titled "Idiot Tries to Kickstart a Game that was already on the Game Crafter." And that was like literally, life comes at you fast, bro, because that was yesterday or the day before. I had a screenshot of it, which would have been a copyright infringement, but it's not in here, so it's not. Anyway, long story short, there is a lot of things that are going on. One thing I will tell you is that the reality of this is that any of those actions, copyrights, patents, trademarks, they take time, they take energy, they take money. If you go out there and to Protospiel and test your game and you have images off Google Images, like, it's unlikely to result in any action against you for that. People may frown upon that, in part because it's expensive, it's hard, and it's very unlikely that the copyright holders, that the intellectual property holders are going to be able to prove access, to know that you actually did this. The inverse of this is true too, which is even if you have a solid claim against somebody who had a game name or game idea or copyrighted work that looks an awful lot like your own, it is equally hard, expensive, and unlikely that you will be able to do much. You can ask politely that they not sell the game that sounds exactly like yours, but unless you're willing to spend the money to shut it down, and unless you have the trademark claims, it's an uphill battle, and you still got to prove a whole bunch of other things that we didn't go into, like damages. So, thank you. I'm at the end. You can send any complaints about this to Asmodee. They will answer. So, if you got questions, I'll take them now. Yeah.
Does that happen often, that people steal other people's ideas for games? I mean, is that a common occurrence, or?
The world is a nice place, and everybody gets along perfectly. I mean, it's often enough that people complain about it. They get awfully close. There's usually community outrage about, near ripoffs, things like that. Even reskins that people dislike or think are distasteful, even if they aren't direct copyright infringement. Similar sounding names comes up all of the time. I get asked maybe once a year, hey, this other game's about to come out and it has almost exactly the same name. What do I do about it? And it does come up. Yeah.
You had something about share alike that you didn't talk about out loud.
Yeah, sorry. So Creative Commons has a share alike license too, which is kind of a hard one for most game designers, because that's basically going to say, if you're going to use this, anything that you use it, you have to make available in a similar form. So like if you're going to sell it or otherwise. So again, like it's kind of hard. Yeah, it's a copyleft. If anybody's familiar with GPL or copyleft, if you use it, it's sort of that same license would attach.
I got the impression that it was like, let's say I got an image off of that, it was share alike, and I reprocessed the image. I just had to reshare the image, not like I'm going to put in a game. I didn't think I had to like.
So play that out, because.
Make the product.
Yeah, so play that out for a second. If you put the art on a card and you add text, you crop it, like where does the new derivative, where does that art stop? Is it at the literal border that you created, or is it the card itself?
But wouldn't it be kind of once I shared it into share alike, I have to find what it is. Well, yeah, but it's share alike.
Yeah, so this is the problem. Like, and there's no great case law about any of these things. And again, it comes down a little bit to this. So like whether you got a piece of art off with a share alike license, you may be right. One way to look at it is, all I did was take this, it's here, it's in a frame, I cropped it, I will share that piece of the artwork again. That is your interpretation. I can't guarantee that that's going to be everybody's share alike, because the other way is, well, yeah, but you put it into this gigantic thing, here you put a frame around it, you did all of these other nice things to it. Does that itself become the art? So, with it. Yes. So it's a little messy. Again, the safest way, the attribution ones are probably the safest of the license if it's just the Creative Commons by. There's a copy, all the copyleft ones are really kind of messy.
Oh, hey, can you also talk about like licensing sites that you recommend as far as like places you can go to get licenses like Shutterstock, but competitors of theirs? Other suggestions?
I have not done a full evaluation. So I've used Creative Market. I've used Humble Bundles when they sell game packs, because almost all of those have largely restriction-free commercial licenses available. If you've never seen the Humble Bundle ones, they're kind of amazing. You pay like $15 and get a gazillion sort of stock images with commercial licenses. There are a couple other places that you got to be careful, especially if you're going to do a gigantic print run, say more than 10,000 copies. Even some of the Shutterstock licenses don't let you print that much. So, I mean, they're all, you pay for, basically you pay for what you get, and so you just got to be careful.
Stock Unlimited is one. The Game Crafter has its design asset section where people are starting to put stuff up.
Right.
There's a lot, I mean, if you do the search, you'll get a ton of hits.
Thanks, Jeff. Yes, so if you didn't hear that, Game Crafter has a design assets. There's a pitch. I've got stuff up there that is you can get for commercial use. There's a few of them. Yeah.
So you said the copyright is automatically you gain, right?
Yep.
But what is the point of then the copyright.gov site? You apply as a what's the point of that?
So the question is, what's the point of registering your copyright if it's automatic anyway? So there's a couple reasons. The biggest one is that the moment that you register your copyright, you're actually eligible for statutory damages. So statutory damages avoid the messy issue I didn't want to get into, which is how do you actually prove the damages caused by the copyright infringement. So registering it would make you eligible for a range of monies that's set by statute, and you don't have to go down that path. The other reason to record your copyright, other than getting your game in the Library of Congress, which is in and of itself kind of cool, right? Is that it actually lets you into federal court. So you cannot file a copyright infringement claim until you have a registered copyright. You can't go into federal court and sue. It's just a hurdle. People don't, you can record your copyright and then sue. So like if this actually becomes an issue and you didn't, it's not a big deal. You go and record it right before you sue. So I think we are running out of time. I will take questions not in here so that we don't disrupt the next presentation. Afterwards, I'll be here, not tomorrow, but the rest of the weekend. So thank you, everybody.